Hello, everybody. I am Ray Cepeda. I'm the founder and director of ABA Skills, and I'm very happy to be hosting this event tonight because it's something very different than what we usually do. So instead of talking about teaching procedures and behavior intervention plans, I really am glad to be welcoming our two speakers, Julie Kennedy and Chris.Kelly, tonight to talk about estate planning and how to plan for your child with special needs future. I know that it's definitely a hard topic to discuss, but it is one of the realities of having a child with special needs is what's going to happen with that child in the long term. So Julie and Chris will be able to answer a lot of your questions tonight. And I'm really looking forward to this presentation. So Julie Kennedy has been practicing law as a litigator for almost 25 years. For the last 11 years, Ms. Kennedy's practice has been mainly estate litigation, including estate planning, adult guardianships, special needs planning, and guardianships for developmentally disabled adults. Ms. Kennedy brings the highest level of care and focus to her clients when assisting them through the process of planning for the future with the development of an estate plan, trust, or guardianship that fits her clients and their families' particular needs. Ms. Kennedy attended Villanova University for undergraduate studies and graduated with a major in political science and a double minor in English and Spanish. She received her JD from Widener University School of Law in Wilmington, Delaware. She has been involved in Special Olympics New Jersey, previously led her district special education parent advisory group, and taught CCD so her son could attend religious instruction. That's pretty impressive, Julie, I gotta say. Chris.Kelly is a financial advisor with Equitable Advisors in Wall, New Jersey. Chris has been with Equitable for 8 years and has over 25 years of experience in the wealth management industry. Prior to Equitable, Chris was a senior vice president at Wells Fargo Private Bank. He has a Bachelor of Science degree in economics from the University of Maryland, College Park. And Chris assists his clients with all aspects of their wealth management, investments, insurance, retirement, and estate planning. Chris is active in the community by serving on the boards of the community YMCA and Two River Little League, and is a member of the Philanthropic Advisory Committee for Hackensack Meridian Health Foundation. So again, welcome both of our speakers. And now, Julie, I will turn it over to you.
Thank you, Ray. Thanks for having us tonight. We're really happy to be here, and we hope that we can provide you all with some useful information when you're planning for your child with special needs. I am going to attempt to share my screen. And here we go. Okay.
There we go.
Okay, so we're talking tonight about succession planning. And if you fail to plan, you plan to fail. That's the old adage, and it rings true here. Succession planning is a term we usually use in corporations when you're planning for the continuity of the corporation, to have the corporation live beyond the founder or beyond whoever's in charge now. And I use that phrase because that's really what we're trying to do here, is make sure that the program and the lifetime plan that you put in place for your child with special needs lives beyond you. And when we're talking about that plan that you're putting in place, there's a triggering event, and the triggering event is typically the death of the second parent. So upon the death of the second parent, the loved one with special needs is going to lose their parents, quite possibly lose their home, and more than likely lose their home, and lose their daily routine in their community. Typically, we find that it's very unlikely that that the adult child with special needs is able to maintain the home or can afford to live in the home. And even if they can maintain it and afford to live in it, there's not always the occasion where there's going to be somebody who's going to be able to provide the level of support for that person that their parents had before they passed. So when that happens, your loved one with special needs is thrown into a great flux. And where do we start? First, we think about who we're planning for. So this beautiful young lady right here has a birthday cake in front of her with the number 60 on it. I am thinking forward to when my son turns 60. I hope he has a great party, but I'm pretty sure I'm not going to be there. So I need to plan for him. And what does life look like for my child when he is 60 or when he is 40 or when he was 20? Where is he going to live? What are his opportunities for socialization? What about secondary education opportunities? Is he going to be going away to school? Is it possible for him to go away to school? What supports does he need to put in place, or what supports do I need to put in place to make sure he's successful at secondary education if that's what he chooses, or at employment if that's what he chooses? When I'm planning for my child with special needs, I'm looking to beyond 60 years old. When we plan for our typical children, we kind of want to make sure there's enough money where they can go to school, you know, buy a car and be able to, you know, maybe put a down payment on a house or a first apartment. We don't typically plan out the lives of our typical children. The first thing we do when we're doing this kind of planning is we get a letter, we make a letter of intent. It's a roadmap for your fiduciaries to let them know what your plan is. I would start with a weekend. It's very daunting to sit down and try to lay out your child's entire lifetime in, you know, the span of a couple hours on a Sunday afternoon. But start with a weekend. What is it going to take to get a caregiver to get your child from Friday to Sunday? If your child is young, Bob the Builder and chicken nuggets might do the trick. If they're 12, you're pretty safe with Marvel and some pizza, Marvel movie marathon and some pizza. But at 25 and 45, that's probably not going to cut it. So what is it going to take to get your loved one through the weekend? And then build on that. Go for a week, a month, a year. And you're going to want to revise this annually, because again, if your letter of intent you made in, you know, this year, but now it's 25 years later, Bob the Builder and chicken nuggets is not going to cut it for your now 35-year-old or 30-year-old adult. You want to make sure that you express your child's wants, needs, and desires. If your child loves animals, you know, volunteering at the local shelter, the local dog shelter, or working at the zoo is a great way for your child to mix their love of animals with a passion for work. And also make sure you put in there about what your plan is for maintaining their faith community, their ties with family, their socialization with friends, and that it's integral that they be a part of the community. When we're planning, we're usually planning with the assets that we have. How are we going to pay for this? So there's two types of assets that we have, and they're probate or non-probate assets. Probate assets pass through the will, and they're typically the house and the car. Non-probate assets pass by beneficiary designation, and that's typically cash accounts, stocks, bonds, IRAs, and other accounts like that. And Chris, I'm going to turn it over to you.
Yeah, thanks, Julie. When we have these conversations, you know, I'm going to use a very technical term. It's stuff. What type of stuff do you have? You know, and I like to say to my clients, it's what you have, how you have it, and what you want to do with it. What you have, that's everything. You see the picture of the house, the picture of the car, stocks, bonds, mutual funds, IRAs, annuities, gold coins, all your collectible things that you own in some way, shape, or form. So that's what you have. How you have it is the title on each account. And as Julie says, probate, you know, things that pass through the will. That is things that have your name on it alone. It's not joint with your wife, joint with a family member. It's in the name of Mary Smith, period. Okay, that will go through her will. Then the other types of assets you want to look at, most common, joint tenants with right of survivorship, typically between husband and wife. Those titles, the assets will pass directly to the surviving spouse. All you need to make that transfer happen is a copy of the death certificate. Then you have TOD, transfer on death. The person owns it and controls it up until the day they die. When they die, the beneficiary who's named on it then takes control over the account. Tenants in common is another title out there. Okay, tenants in common is each owner is assumed to own half of the asset. And then when the first owner passes away, his or her share is distributed in accordance with the terms of her will, his or her will. That's where it gets complicated. Let's say you own a family home, and the wife passes away first, and her will gives it to the children from the first marriage, and then you've got the husband who's still living there. So that's why it's very important to look at the titles, because Julie will talk later about drafting trusts that help provide for care for special needs children and beneficiaries. But if you don't have the assets titled properly, you're never going to have anything flowing into that trust. So when we talk about all the planning throughout the course of this presentation, it really requires coordination between the attorney who specializes in special needs planning like Julie, with a financial advisor who understands everything we're talking about, with an accountant who understands all of this stuff. So it really does take a team approach, a group of people with different disciplines providing the infrastructure and the implementation of the plan. And Julie talked about the letter of intent and updating it annually. The planning that you do is not a one-time event. It's not a static plan. The will you draw up is probably not going to be the last will you draw up, because there'll be other things that happen through the life of the mother, the father, and the special needs child, and the other typical beneficiaries that need to be addressed. And then remember, things that go into the trust don't get transferred maybe until an event in the future, like the passing of the mother and the father. Julie and I were talking about this, and do you split everything evenly? Well, it really depends. When you look at the care for a special needs child, it's not just caring for that child while you're alive. It's making sure you've got all the resources available to you to provide for that child beyond your life and for the rest of their life. And also making sure you're working with professionals that understand all the government programs that are available to the special needs child. Again, not just while you're alive, but for the rest of their life. Not only do we have to worry about how the assets are distributed, when will the assets be distributed? And another thing which we want to talk about is accounts and assets that are distributed by beneficiary designation. And when I'm talking about this, I'm talking about life insurance, I'm talking about annuities, I'm talking about IRAs, right? And all the different beneficiaries, because these assets do not pass through probate. The will have nothing to do with how these assets are distributed. However, every now and then there'll be a situation where a client will name the estate as the beneficiary, which is probably the worst thing that you can do. So that's why you want to work with an estate planning attorney and a financial advisor and accountant who understand how all of these things work together to make sure you've got as much flexibility in distributing these assets, not only while you're alive, but when you pass away.
I think one of the other things I like about the beneficiary designations for non-probate assets is that it provides a lot of flexibility. So when circumstances change, you can easily change the beneficiary designation. So if one of your children, say, is going through a divorce or going through some other issue, or is sick or is in financial distress, you can change the beneficiary designation without necessarily having to change your entire estate plan.
And that's very important, because divorce rates are over 50%. So it really does require you to, we talked about updating your estate plan and having your will being revised. Same with beneficiary designations, right? Things happen, divorces happen. And also protect yourself when you're filling out the beneficiary designation form. Provide for a contingent beneficiary, okay? You can change the beneficiaries as many times as possible, but hey, life gets busy and sometimes we don't get around to it. But if you've got the contingent beneficiary named, you give yourself a level of protection there.
Okay. What are the types of estate planning tools that are available? So I think most people are familiar with the last will and testament, the power of attorney, and your advance directive. But just to go over the last will and testament, it disposes of your real and personal probate assets after your death. Your tangible stuff is your, Aunt Helen's crystal vase and that painting that you love, and your house. That's going to go through your last will and testament. Cash accounts, again, we talked about that before, typically non-probate assets, and they will pass by beneficiary designation unless there is no beneficiary designated, in which case they will go through your probate estate. The power of attorney is a document that permits you to appoint an agent who can transact business on your behalf during your lifetime. The power of attorney, your agent under power of attorney is going to be able to buy and sell a house, open and close an account, take out credit cards in your name. They're going to be able to do anything that you can do with respect to transacting business. So when you appoint someone as power of attorney for you, you want to make sure that that person is the right person to appoint for that. If they're not good with money, you might want to try to find another person to be your power of attorney. There's also different kinds of powers of attorney. You can have a power of attorney that does not go into effect until your disability or until you become incapacitated or disabled. For instance, if you get in a car accident and you're in a coma for a couple of weeks, your power of attorney has the authority and ability to, keep paying your mortgage and pay your health insurance and life insurance. And then we have the living will and advanced healthcare directive. So I think most people are familiar with this document. Oftentimes in the hospital, or every time in the hospital, they ask you if you have one. And if you don't have one, they ask you to sign a form and create one. So if you already have one and you sign that form in the hospital, you've just replaced the one that you had. So it's very important in the hospital, if you have a living will or advanced healthcare directive, make sure that they know you already have one. Don't sign another form. And know that when you have the healthcare proxy, the person who's going to carry out your wishes in the hospital, they're going to go down the list. So for instance, my husband's number one, maybe my one cousin is number two, and my other cousin is number three. If my husband was in the hospital, if my husband was in a car accident with me, he doesn't answer the phone, they're going to go down to the next phone number and then the next phone number. So while you have your first person there, if they don't answer the phone and it's an emergent matter, they're going to just keep going down the list until somebody answers the phone. But the living will, oh, I'm sorry, go ahead.
No, Julie, pardon me for interrupting, but just looking at the timeline of these documents, like the power of attorney, like Julie said, it stops when the person passes away, and that's when the last will and testament takes over. But we want to make sure our clients have their documents as flexible as possible. So often we get involved in having a durable power of attorney in place, which says that the power of attorney is still effective even if the person who created the power of attorney is disabled or incapacitated. Because if you don't have that type of language in the document, and Julie, I should let you talk since you're the attorney on this, but I've been doing this long enough that I've seen so many of these circumstances where things just come to a grinding halt because the documents aren't done properly. So if you don't have what's called the durable power of attorney, the power of attorney could effectively stop while the person is alive but incapacitated. So that's why you want to make sure you've got the durable power feature in the power of attorney.
Absolutely, that's a great point. I've seen, we typically only do a general durable power of attorney unless there's some reason we're doing a very limited power of attorney. For instance, if I would do closings and the client would sign a limited power of attorney allowing me to sign whatever document needed to be signed at their closing because they weren't going to the closing. But otherwise, for a regular power of attorney, the documents that we do usually are general durable powers of attorney. And we have clients who choose to have the document effective immediately. And we have clients who choose to only have the document become effective when they're incapacitated.
And I think you're beginning to see that planning for a special needs child also involves all the other basic estate planning things, like making sure your will is up to date and the power of attorney. And the problems we see on this is when people try and do the documents themselves when they're not attorneys, or they go to LegalZoom or whatever, and they try and, you know, check some boxes. So that's why it's really imperative that you work with a group of professionals who are very familiar with all of these components of estate planning.
So another tool that we typically use with regard to planning for our children with special needs is a trust. So whether it's a special needs trust or a supplemental special needs trust, the assets, for instance, the house is upon my death, there's nowhere for my house to go, assuming my husband has predeceased me. My house is going to be it's an asset of mine. It's going to be collected by my executor, and my executor, according to my will, is going to put the proceeds of the sale of that house, or the house, if my children are going to stay there with a guardian, that goes into the trust. And the assets are held by the trustee of the trust for the benefit of another. So it would be, Bob Smith as trustee for Julie Kennedy's family trust. And Bob would hold those assets in trust. And depending on the type of trust you have, there's several different ways you can set up a trust. One is by your will. You can have a trust set up to become effective upon your death, or you can have a standalone trust. The problem with the testamentary trust is it doesn't come into effect until your death. So if Aunt Barbara wanted to leave money to my son and I have a testamentary special needs trust, she can't do that while I'm alive because it's not created yet. Or you can have a standalone trust, which is going to be set up as its own document. It stands alone. It has a tax identification number. It has, if it makes money, it's filing taxes, and the trust can be discretionary or directed. Discretionary trusts leave the total discretion of everything going on in trust to the trustee. Directed trusts are directed by other fiduciaries involved with the trust. Chris, I don't know if you want to talk about the different kinds of the discretionary versus directed trusts and the.
Well, yeah, the discretionary, generally speaking, gives full discretion to the sole trustee for all aspects of the trust administration, the investments, the discretionary distributions, and the directed trust kind of bifurcates the trustee's duties. Like you could have one trustee who is in charge of the investments and another trustee who gives direction as to how the funds are to be distributed, especially when you have a special needs trust and we've got to worry about protecting the trust to preserve the beneficiaries' government benefits. So discretionary and directed really pertains to dividing the trustee's duties, especially when you have something like the special needs trust.
One other thing, there's a lot of talk right now, not a lot of talk, there's a lot going on right now in Congress with respect to trusts, and there's sweeping changes coming with respect to the different kind of trusts that are available to use as estate planning tools. We don't know exactly what's going on with them right now. Right now it's still in Congress. It hasn't gotten to the Senate, and we don't know what's going to happen when it comes to the Reconciliation Committee. But I think by December, there might be some new changes that we're going to need to address with respect to trusts and assets held in them. Another type of estate planning tool is an ABLE account. And an ABLE account allows an individual with disabilities to save up some amount of money and it's something that everybody should have. It's a 529A account, and we're going to talk about that in a little bit. But I wanted to talk about supplemental needs trusts versus special needs trusts. We generally refer to all of these as SNT trusts. But the difference between a supplemental special needs trust and a special needs trust is very important. And you need to know this, because if you don't, and you put money in the wrong one, you may be losing all that money to Medicaid. So supplemental special needs trusts are third-party trusts. That means the grantor is not the beneficiary. If I have a trust for my son and I have an account that I put into the trust, I'm the grantor, I'm putting that account into the trust. The beneficiary of that trust is not me, it's a third person, who is my son. Upon his death, the money remaining in that trust would be distributed to the beneficiaries. So my other child or my other children. There are limitations on what the trust can spend money on, and that's very important. The trust is meant to supplement and not supplant public benefits that my son would receive. If there is too much money spent on items that would be covered by public benefits, the trust would be in danger. Special needs trusts are first party trusts, or we also call them self-settled trusts. So I would set up the trust and I'm going to put my own money in there and I'm the beneficiary. So for instance, this gentleman here on the corner of the screen, he's working and he could put his money into the first party trust. Upon his death, however, if there are any Medicaid liens, they will need to be repaid from the trust. More than likely, there's not going to be anything left over to distribute to any beneficiaries.
And, I want to harken back to what we talked about with the types of the titles on the accounts and the beneficiary designation. So Julie can put together the perfect legal document for whether it's a supplemental special needs trust or a special needs trust, and everything can be working perfectly. However, if someone passes away and the special needs child is named as the beneficiary, let's say, of a life insurance policy, then all of a sudden he's or she is getting money outright outside of these trusts, right? Which can create a problem in terms of he or she qualifying for government assistance program. So again, it's what you have, how you have it, and what you want to do with it, and making sure the beneficiary designations are in concert with the overall special needs planning component of the estate plan.
Understanding that special needs trusts, they're not inexpensive. I mean, depending on where you are in your life right now, it may be something that you want to use. It may be something that you want to look at completing in another few years. But there is also another tool available, and that's the ABLE account. It's the Achieving a Better Life Experience Act. And even if your goal is to have a special needs trust, or if you already have a special needs trust or a supplemental needs trust, really consider opening an ABLE account. It's a 529A account. There are eligibility requirements. The disability onset has to be before age 26. They're trying to get it up to 40. I'm not sure where that is in the mix, if it's 40 yet or if it's still 26. You must be receiving SSI and or SSDI. If you're receiving those, you're automatically eligible. If you're not receiving either, you may still be eligible if you meet the Social Security definition of disability, or if you have a letter of disability or certification from your doctor. The ABLE accounts, the whole purpose was to secure funding for disability-related expenses on behalf of designated beneficiaries, again, that will supplement but not supplant benefits provided through public resources. So if you break your glasses and you need to get another pair of glasses, but Medicaid doesn't cover it, you can use funds from your ABLE account to buy a new pair of glasses. The money that you have in an ABLE account does not count against a person's income for the eligibility requirements and means and resource tested public benefits, which is wonderful. And you can have up to $100,000 in the ABLE account. Deposits, however, are limited to $15,000 a year from all sources. So if I put $1,000 in my son's ABLE account and Chris puts $1,000 in my son's ABLE account, my mom, for instance, can't put $20,000 in. You're limited to $15,000 a year from whatever source. The money, much like in a supplemental needs trust, needs to only be used for qualified disability expenses. This includes transportation. This includes if you have to hire a work coach to go to work with you until you're paid support. If for healthcare that's again not covered. So in addition to glasses, if you need some other special glass that Medicaid definitely doesn't cover, if you need a lift or something again that Medicaid doesn't cover or that isn't covered by any insurance. Assistive technology. So if your iPad breaks, if your iPad falls and you need to get a new iPad and you can't communicate without it, that's a qualified disability expense. And so it provides and gives people a way to save some money to pay for expenses. You can only have, what, I'm sorry?
And I was going to say, for people who are familiar with 529 accounts for college and post-high school expenses, these operate very similarly. As Julie had a couple slides back, these are 529A accounts, right? So as money is accruing and invested in this account, the dividends and interest and capital gains are all accruing or accumulating tax-free. And all those distributions that Julie just mentioned, the iPad that broke, the glasses, so on and so forth, those are paid out tax-free. So for anybody who has a 529 account, a traditional 529 account to help pay for post-high school education, the ABLE accounts work very similarly.
I'm also just noticing as an aside that the closed captioning is not picking up every single word. It's doing a great job. But to the extent it's not as accurate, my apologies for anyone reading these. But I mean, most of them are great. I just happened to notice one that was not as accurate. The earnings that an ABLE account makes are not qualified. They don't qualify as taxable income. You can, however, have only one. You can't have an ABLE account with $100,000 at PNC and another ABLE account at, with another bank or with another ABLE account in another state that offers ABLE accounts with another $100,000 in them. There is a Medicaid payback provision. Upon the death of the beneficiary of the ABLE account, any assets remaining must be used to reimburse them any Medicaid liens on behalf of the beneficiary. And during the lifetime of the person with disabilities who's receiving Medicaid, those Medicaid liens could be very extensive. So we then ask, which estate planning rule, which estate planning tool is right for me? And we always say that that depends on the size of your estate, the type of your assets, and how they're held. New Jersey is a very probate-friendly estate. We typically don't advise our clients to get a revocable trust. However, Florida and New York are not necessarily probate-friendly, and you'll see many people in New York and Florida that do have revocable trusts. Another thing, oh, go ahead.
No, yeah, probate in New Jersey is very easy, and it's very inexpensive too compared to other states such as Florida and New York. So that's why you don't see a lot of revocable living trusts like Julie mentioned here in New Jersey. New Jersey does have an inheritance tax. We did away with the estate tax a couple of years ago. So the inheritance tax really kicks in when the assets are distributed outside of the immediate family. So distribution of the assets to children, grandchildren, not taxable. You can even go up the family line to parents, grandparents. But once you go outside to nieces and nephews, that's when you get into some taxable distribution. So probate and estate administration in New Jersey is very easy and affordable. Florida, New York, not necessarily. And the reality is, whether you New York, New Jersey, Florida, the reality is a well drawn up estate plan is going to have some type of these strategies in there. You're going to need a will. You're going to need a power of attorney. If you have a special needs child, you'll have some type of special needs trust drawn up, whether it takes effect during your lifetime or at death. So I think we just want to get the message across that there's not one document that's going to do everything, and you only do that once. You should be doing multiple documents over your timeline, and they can be revised. Sometimes they're replaced with other documents. But the best estate plan is going to combine all of these different strategies and consider input, like I said before, from the attorney, the accountant, the financial advisor, the insurance advisor, so on and so forth.
And I always think of it, inheritance tax is who is inheriting, and estate tax is how much. So as Chris said, up and down your family line, there's no inheritance tax. And as you go out, the inheritance tax comes into play, although there are some exclusions for a certain class of beneficiaries. Not many, though. But the estate tax, again, is how much. Right now, it's at $11.5 million for a single person. But at the end of 2025, it's going to be reduced down to $5.5 million if nothing else comes into play before that. And again, you want to consider what asset works best for which beneficiary. You don't necessarily want to give your niece, who is going to be paying estate tax, an asset. If you're trying to minimize her taxes, one thing you might want to give to her is life insurance, because she's not going to be paying tax on that. But if your life insurance is funding another trust, then that's not going to work for you.
And that's particularly important with retirement accounts like IRAs and 401ks, because the person who inherits those assets will pay taxes on them when they come out. And we'll talk about this a little bit later, how the Secure Act that was created in December of 2019 changed the way non-spouses can inherit retirement accounts like IRAs and 401ks. So, but the point is, when the money comes out of IRAs and 401ks to the eventual beneficiaries, that they are taxed as income. So Julie just used a charity as an example of a beneficiary. If you are giving money to charity, okay, sometimes it is more tax efficient for the non-charitable beneficiary to receive the life insurance than the retirement account. So in that simple example, let's say you have $1 million of life insurance and $1 million of an IRA, and you want $1 million to go to your child and $1 million to go to the charity. The most tax efficient way to do that would be to have the charity named as the beneficiary of the IRA and the life insurance to go to the child. The life insurance goes to the child tax-free because life insurance death proceeds are not taxable. The IRA goes to the charity tax-free because the charity does not pay income taxes. So again, what you have, how you have it, and what you want to do with it.
And
so I have a quick question. So the question is, can a 529 plan be converted to a 529A account or other option if the special needs child will not be attending college?
Yes. Yes. The answer is yes. You can convert a 529 to a 529A. It's going to depend on how your where your 529 is and where your 529A will be, depending on what state you're in. Each company has its own set of rules, but yes, you absolutely can convert a 529 to a 529A.
Great, thank you, Julie.
So Chris just mentioned giving the $1 million to your child with special needs. And just to be sure, we want to make sure that that doesn't necessarily go to that child, but that goes to that child's bucket. So that would go into the SNIT trust. I have this visual. It just helps me when I'm explaining, and I'm hoping it helps people when I'm other people who are listening when I'm explaining that you want to make sure, if you picture your estate plan as sort of, the liquid funds, filling up buckets. So your house and your car would be in your estate, and which bucket is that going to fill? Well, if it's going to your 19-year-old typical child, that bucket is going to go into, or that person's share is going to go into the minors trust. The minors trust will provide asset protection and a level of oversight, so your 20-year-old doesn't walk away with $500,000. Now, if the other half of that money is going to your child with special needs, that's going into the SNIT trust. But that's assuming, for instance, a life insurance policy that was payable to your estate. Or some other, $1 million house that was sold and the money's then being distributed. Another bucket that we use in estate planning is disclaimer trust. So if your assets are at a level, say if there's $6 million, you give, and your assets are going to your spouse can disclaim those funds, and the disclaimed funds would go into what we call a disclaimer trust, or sometimes referred to as a bypass trust.
And each of these buckets has different tax ramifications too, because even if a trust, let's say it's a disclaimers trust, is not distributing the income out to the beneficiary, that doesn't mean the income is not being taxed, because the trusts are their own taxpayers, they have their own tax ID numbers, and the taxation of the taxable items will depend on where those income items end up. Again, that's why you really need a team, an attorney, a financial advisor, and a CPA to make sure all of these buckets are being managed properly from an investment and a tax perspective.
The next thing we want to do is, when we think we know what assets are filling what buckets, we want to check our buckets. So I think Chris and I can't stress enough the importance of checking your beneficiary designations to make sure what you think is going into your estate to be distributed by your executor is actually going there, versus what's going to a minors trust or a SNIT trust or to somebody outright.
And just before we hop on to the next topic, Julie, I just want to go back to the retirement accounts and the Secure Act. Like I said, in December of 2019, the Secure Act changed the way non-spousal beneficiaries can inherit IRA retirement accounts. Okay, 401k, SEP accounts, simple accounts, IRAs, all of those have a beneficiary designation. And before 2019, the beneficiary, because remember, all of that is tax deferred money. So there's no such thing as a free lunch. The IRS wants to tax the money when it comes out. So let's say you had an 80-year-old IRA account owner who passes away, and he had a 30-year-old grandson who was inheriting the IRA. The only requirement was that the 30-year-old grandson had to take out required minimum distributions starting at age 30. Okay, that's no problem, because the life expectancy of a 30-year-old is probably 50 years. So that's no problem. December 2019 rolls around, the Secure Act goes into effect. And what that did, it said that no more stretching out the IRA. Like I said, the 30-year-old no longer had the option of stretching that the required minimum distributions from his inherited IRA for another 55 years. The Secure Act said that inherited IRA, the 30-year-old now has a 10-year time period. He has to withdraw the money. He can not take distributions for 9 years, but in the 10th year, he has to take all the money out. Or maybe in year 1, he takes all the money out. Maybe he waits for 5 years and takes all the money out, or takes half out in 5. But you get the point. So that's very important from a post-mortem planning perspective of how to deal with that asset. That asset is different from a life insurance policy, which is paying money tax-free. So again, it's what you have, how you have it, and what's going to happen to it after you pass away.
Okay, when we don't check our beneficiary designations, we have unintended results. So that life insurance policy that you got 3 years before you made your SNP trust and your estate plan still had your spouse as primary and your kids as contingent beneficiaries. So they're going to inherit equally because unfortunately your spouse passed and then you did shortly later. So your children are going to inherit outright. That means your child with disabilities is going to lose their public benefits, and your 19-year-old just met a really cute boy with a leather jacket and a motorcycle, and they're going to go take their money and go bet it all on red. There's no oversight for that 19-year-old. There's no asset protection because it didn't get to the minor's trust. And I know a 19-year-old is not a minor, but when we talk about minor's trust and distributions that we have in our wills for our children who are younger, we extend the age out to 25, 28, and 30 so that it affords them asset protection for a significantly longer time. It's not to say that they can't, request the trustee distribute those funds to them, because they absolutely can, but with a provision where it's discretionary on the part of the trustee, but based on a health, what we call a HEM standard, a health, education, and maintenance standard, health, education, and welfare. The trustee can say, sure, I'll pay for college. Sure, you can have a Honda. Sure, I'll give you some money for your first house or your wedding. But you're not guaranteed it. And I don't have to do it because it's discretionary. So if that, now 22-year-old made a poor choice or was sick and now has a lot of medical bills, the creditors can't come knocking on the door of the trust to try to get that money out from the 19-year-old. Now, with respect to your child with disabilities, they're going to lose their means tested governmental benefits, including supplemental security income, which requires that all assets must be under $2,000 and under $3,000 if that person is married. Well, for the couple, when you receive SSI, you also have to apply for any other benefits that are available. And also additional services may be available, and you must be Medicaid eligible. Medicaid eligibility depends on a couple of requirements, but basically you must be permanently disabled. You receive services from the Department of Developmental Disabilities. There are home and community-based services that come and provide additional support for people with disabilities. And over the lifetime of the person with disabilities, the cost of care provided by Medicare and the services that they receive could be well into the millions. There are programs that will not even take a person with disabilities unless they are receiving Medicaid benefits. So the next thing we talk about is who's in charge of your buckets. And those are the fiduciaries. For the estate, we're looking at the executor. And actually, I'm going to, Chris, turn it over to you because on the SNP trust, we have a corporate trustee in charge of this bucket.
Yeah, and remember, each one of these buckets has an underlying document which says how things are to be managed. And Julie used the term fiduciary. So the document, whether it's a will or a trust document, is going to give powers and instruction to the executor or the trustee, but also state law also governs the basic behavior of what a fiduciary can and can't do. So the estate, that's pretty much a limited time trust or a limited time vehicle. Person passes away, the executor collects all the assets that's in the name of the decedent, transferred into the name of the estate, but the executor is also responsible for distributing or marshaling the assets that may be in different titles and getting them transferred to the named beneficiaries. So the executor may not collect the IRA, but the executor is responsible for making sure the beneficiary of the IRA is aware of that account and distribute it out to him. And also remember, as I said before, all of these buckets have have tax consequences. Sometimes the income may be taxed out to the beneficiary. Sometimes it may be retained by the estate or the trust and incur its own income tax bill. So the basic responsibilities are the investment management of the account, making sure the trust is invested at the appropriate risk level. Like I said, the estate is more of a preservation account. You know, you're collecting the assets and then distributing them out to the beneficiaries, whether it's a trust, a charity, or an individual. Special needs trust and the disclaimer trust, those typically have lifetime beneficiaries, right? So the assets need to be managed in a way to provide a benefit for the beneficiaries over their lifetime, and then distribute out to what's called the remaindermen, the beneficiaries that are left to take over the assets that remain when the person passes away. The minor's trust is a little different, where it's held in trust until the minor achieves certain ages, and that those distribution ages can be anything you want, because when you sit down to draw up a trust, whether it's a revocable trust or a trust that takes effect after you pass away, it's a blank document. It's a blank page. So the person who's creating the trust can pretty much say anything they want, as long as it doesn't violate any laws that are on the books at the time. So you can say distribute half the trust at age 30, a third of the trust at age 40, and the balance of the trust at age 50. That's just one example. You can really say anything you want. So you have to marshal up the assets, invest the assets, pay appropriate expenses on behalf of the beneficiary, and then when that beneficiary passes away, distribute it out to what's called the remainderment, or with the minor's trust, distribute it out to the trust when he or she attains the termination age.
Chris, with respect to fiduciaries, what's the difference between a corporate trustee and a trustee?
Yeah, whether it's a corporate trustee or trustee, your responsibilities are the same. A corporate trustee has to do with an organization, an entity serving as the fiduciary. Bank trust departments are typically the corporate trustee. These are typically for-profit entities, but the attraction to them is that they're specialists. They're also known as professional trustees. They have policies and procedures in place and how to handle all of these responsibilities. I mean, if you named your brother or your sister as the trustee, they may not know exactly what to do. The corporate trustees do this each and every day. So they have policies and procedures in place. And one of the main reasons people use a corporate trustee is because of the permanence. A corporate trustee is not going to die. A corporate trustee is not going to go out of business, even though there's every once in a while you'll see a bank that goes out of business. But then there's the state laws will take over about how the corporate trustee has succeeded. So the main attraction to having a corporate trustee is the expertise, the infrastructure that they have, and the permanence. The downside to it, and I started my career working in bank trust departments, is the bank trust departments are in this to make money, right? So we're going to have higher fees, and also with the amount of resources that they need to perform their duties, they may have higher minimums. And you'll see this with the bigger banks They may have minimums of $500,000, $1 million or more. So it's less emotional, I guess is one way to say it. Some say it's, the cold-hearted bank. All they care about making money, as opposed to an individual. But what you can do is, and we talked about this before, where you bifurcate the trustee responsibilities. You don't have to have just one trustee. You can have multiple trustees. So maybe you have a corporate trustee because of their expertise and their infrastructure, and maybe you have another family member as a trustee, and that family member has the final say as to how funds are distributed for the benefit of the surviving spouse or the minor, so on and so forth. So, and then maybe that family member also is given veto power to remove the corporate trustee. But you can also have a provision saying there always has to be a corporate trustee. So again, it's just having a conversation with the advisors who are involved to see what is the best scenario for the trust to accomplish its goals, which is taking care of the beneficiary in the most cost-effective way.
Thank you for that explanation, Chris. I have another bucket down here for the guardian of the estate. When we talk about our loved ones with disabilities attaining age 18, a lot of times people, they're adults and they're, typically emancipated, but if they lack capacity, we may have a guardian appointed for them. And the guardian there's the guardian of the person and the guardian of the estate. The guardian of the estate has a smaller bucket because typically the person who is incapacitated is only receiving SSI benefits. And hopefully there's been some planning done around this person where there's a SNP trust or an ABLE account where the person doesn't have an overabundance of benefits that would reduce their amount of benefits from the government or would have them lose those benefits altogether. So the guardian of the estate has a much smaller bucket, which is typically the rep payee account from SSI. So for our fiduciaries, Chris talked about the corporate trustees, and the benefit of the corporate trustee is that while they're in it for money, it's their job and it's their whole business. Because what trips everybody up is what you don't even know that you don't know. So there's duties that the trustee has to the testator, or the executor has a duty to the testator and the beneficiaries. The trustee has a duty to the beneficiary of the trust. So trusts are usually for the benefit of someone. So that trustee has duties to that person. There's duties to account for the funds. But this is something that I think that we don't, as parents of children with special needs, we don't necessarily think of all the time. None of the people that we've talked about have a duty to house your loved one. They need to make sure that your loved one is in a safe place, but they don't need to take them in unless we're talking about, perhaps a minor or something. But my brother is he's testamentary guardian of my children should something happen to my husband and I, and my hope and fervent wish is that he comes and he's gonna take care of my kids, and that's what he's agreed to do. But my kids are going to be 18 and he doesn't have to house them forever. They're going to be emancipated at some point. But with my child with disabilities, he's going to need a guardian. And if my brother becomes the guardian, he still doesn't have a duty to live with him. He must see him. He's got a duty to see his ward once every 3 months. But even the trustee, whether it's a corporate trustee or another relative, there's no duty that trustee has to house your child. But they do have a duty to make sure that your child, the beneficiary or their ward, is living in appropriate accommodations. One other thing about the corporate trustee is they're probably in proximity to your child. If you have a local company, if you have a local corporate trustee. For instance, I think, Chris, we were talking earlier where Wells Fargo is there's just a 1-800 number, not just a 1-800. Wells Fargo has, I guess there's a, who do you call it, Wells Fargo?
Yeah, the bank trust department, and this isn't just for special needs trust. You could be administered through a call center. So you're talking to somebody in an entirely different part of the country, and hey, they'll do a good job managing the investments and doing the tax returns and everything. But as Julie's saying, you really need somebody who's on the ground with the special needs beneficiary, and we're starting to see. Trust companies pop up locally that have more and more resources to take care of special needs families. So I think that's something that we as advisors need to keep an eye on, and we're happy to be in touch with anybody on this call who wants to know more about it. But it's more than the typical trust department relationship was manage money, invest the money, and send out the income. But over the years, we've seen the needs of a special needs family and providing for a special needs child. And it's more than just investing the money and paying it. You can't just pay out the money because you're going to possibly jeopardize their government assistance or government programs. So you really need to have a partnership with a corporate trustee. Bigger isn't always better. And I'm not criticizing the big ones, but just, everything we're talking about has a very emotional component to it. I mean, I can talk to you all day about investments and rate of return and all this great stuff, but there's a personal emotional component here. And the better team you have in taking care of this and helping and letting people utilize their specialties, as opposed to thinking one person can do everything, is, I think, the best way to handle these types of buckets, as Julie talks about, especially the buckets that address the needs of a special needs beneficiary.
And I think one thing that Chris, you and I have talked about before is having that with a directed trust, certainly. Well, maybe you have a professional trustee in charge of the trust. They also, there's another fiduciary involved in there, which would be the financial advisor or the investment company who is going to manage those funds, so that now you have the professional trustee and the professional management company, and they're making sure the other one's doing their job.
Mm-hmm. Yep, because everybody's on the hook. That's a good point, Julie, because you have as a fiduciary, you have a responsibility, a legal liability here. And if you know the other trustee is not doing a good job, you can't just say, oh, that's not my problem. You're on the hook too. So, but that's a whole nother topic for another seminar. So.
One of the other things that I know we talked about earlier is making sure that the trust document has flexibility. So you want to provide your trustee with flexibility to make decisions that are going to be in the best interest of the beneficiary and be the right decisions for the trust. So the more flexibility, obviously with parameters, that the trustee has, the better the trustee can make decisions and make changes that would afford a better tax liability or afford more services to the beneficiary. One other thing, when we're talking about who will be the trustee and why do I have to think beyond the first alternate or the second alternate, or why do I need to think down the line? I have my brother-in-law right now is trustee of my son's trust. We're the same age. So at some point, my son's going to be 60 and my brother-in-law and I are not going to be here. So I have to hope that he has appointed somebody who also, I know Chris and I just talked a lot about corporate trustees, and I had a long time ago, my son's trust prepared by another attorney. And I was not comfortable with a corporate trustee. I thought it was this, big, unfeeling business. And now as I'm doing more and more and seeing so many benefits of having a corporate trustee. But here's the thing. If my brother-in-law picks somebody who doesn't necessarily know my son and it's a more distant cousin, or it's somebody who's not even born yet, I'm relying on to take care of my son. They may not know my son. They may not know his disability. Maybe they only see him once a year at a family function. And maybe they just don't get it. Maybe they just don't get that my son is able to do all of these wonderful things. And maybe they just see a person with a disability. And again, that's true of, could be true of anybody, anywhere. But it just, the thing that we're going for is continuity of services for our children, continuity of benefits, continuity of their standard of living and how they've been interacting with their community. And if your one sibling is a trustee for the other sibling beneficiary, you're always going to have sort of a struggle and a rub where the one sibling who wants the money is going to be at odds with the sibling who's the trustee. And if they have a falling out before this relationship even comes into place, you're still left with somebody having to fill the void of the person that you thought was going to do the job that you wanted them to do. The other thing I like about the corporate trustee is that they do an evaluation and make sure that your child with a disability is receiving all the benefits that they're supposed to get, and that they're used appropriately. Because if my son decides he wants to, I don't know, move somewhere else, and whoever the trustee is lets them, and now he's using the funds from the trust for benefits that are provided by a governmental source, he's in jeopardy, and the trust is in jeopardy. So another thing we touched on a little bit was the guardians. So you can appoint or you can name a guardian for your minor children in your will. And you can also name a guardian for this is naming them. It's not automatically done. But in your will, if you name a guardian for your adult child with disability, so you have guardianship over, they're the presumptive nominee. It's going to take a lot for a court to overturn that that part of your will. You'd still have to make an application to the court, but seeing that it's in your will, the court is going to give that a lot of deference. In New Jersey, they started a guardianship monitoring program, which is very important because some people who were appointed guardians were not the appropriate people to appoint as guardians. So now they have to account for the ward's money. They have to, and this is also with adult guardianships too, and they have to account for their well-being. Another thing we talk about, and this is, I know, a hot topic for conversations I have with people regarding guardianship versus supported decision-making. When my son's 18, is he going to need a guardian? How independent is he going to be able to be? I don't know at this point, but my goal, and I'm sure your goal as well, is to make our children as, and we say independent, but we really mean interdependent, make them interdependent as possible. He's going to do what he can do with support, and whatever that looks like is what it looks like. But with a guardianship, you'd make an application to the court, and there'd be either one or two people. One person is guardian of the person, one person is guardian of the estate, and maybe they're the same person. And you need to decide whether or not you're going for a general, or another word for that is plenary guardianship, or whether that guardianship is going to be limited. Are you going to carve out rights for your child that they can vote, that they can decide where they want to go to school and what they want to study? Can they decide who they want to be associated with? Because if you're going for guardianship over your child, you're taking their rights away. And it's very hard for me to think that, and he's going to outlive me, so somebody else will be stepping in as guardian after I'm gone. And if it's not the right person, what if that guardian, what if the guardian of the person decides that no, he can't live where he wants to live, or he can't study what he wants to study, or he can't hang out with that friend because they don't think it's a good idea? the guardian has that power. On the flip side, all contracts that the incapacitated person makes are void. So if your child with a disability tends to go out and sign contracts, if there's a guardianship, all contracts are void. If there's supported decision-making where there's just a power of attorney, but they have a developmental disability, the contracts are voidable. It just takes perhaps some court intervention or a couple of attorneys involved, or it's just a little bit stickier to undo, or could be. But with supported decision-making, it's a group of people supporting the adult with a disability to make decisions about lifestyle, housing, employment. Where am I going to work? What am I going to do? What makes me happy? And that person with a disability has the power of attorney. And a really great resource to find out about supported decision-making is the Boggs Center. They have classes on, I think it's called PCAST. It's the person-centered approach to planning. I know when we're doing IEPs, we're really trying to make sure that we use a person-centered approach, not just this is what your child can't do and this is the class we're going to put them in. It's what does he enjoy? What are his strengths? And typically any perceived deficit in one area is really a strength in another. So he's chatty in class. He's very social. He's probably a leader. SPAN NJ, which is spanadvocacy.org is the website, also has a lot of great resources to learn about supported decision-making. And what do you do when there are no guardians? I don't know if anybody has seen the movie I Care a Lot. It's eye-opening and frankly quite scary if your loved one is in that position. But I mean, it's also a little outrageous. It's not likely, but the Office of Public Guardian is available for adults who are age 60 and older. But there's a lot of people who need support from the public guardian, and I don't know how much time they actually have to devote to each person. There's also the Bureau of Guardianship Services, or if you need to, you can hire a professional guardian. And after talking about all of that, there's still other areas where we need to plan for that don't come under the purview of any of these documents that we can make for you. We've talked about professional trust companies, but one other thing is who's going to make sure that your 60-year-old adult child is taking their medicine or making their bed or making sure they're showering or have the right clothes, or, what if they're, early onset Alzheimer's is a thing with children with Down syndrome. What happens? Who's going to keep an eye on my child to make sure that if and when they need more support as they age, that they get that support? And then that's where the role of care managers come in. And Chris, as working for a professional trust company, can you talk about the interplay between professional trust companies and care managers?
Yeah, it's not ideal, because the trust companies, they're good at the technical stuff, such as filing tax returns and investing. They're not good at the soft the soft stuff, such as understanding the emotional needs of the special needs beneficiary. So and then also they are also worried about liability. So it really takes a lot of understanding of what the special needs beneficiary requires, and then knowing the companies and the resources that are out there to provide. And then this kind of gets back to having a local trust company that's familiar with providers in the area. A lot of this stuff is local to the needs of the special needs beneficiary. But when I was a trust officer a long time ago, no way could I go visit a special needs beneficiary and figure out everything that he needed. So it was a requirement of us to go out and and hire a case manager. Did we have a vetting system for identifying the best case managers? No. And even if you do now, it's always changing. So it's one of those soft features that's required in a trust administration point of view. And I think, again, it really requires a team of specialists to provide their expertise in making sure the trust is doing everything it can to accomplish its objectives, especially when it comes to a special needs trust.
And I know Chris and I have been talking about this as well. There's not a lot of trust companies that deal exclusively with special needs trusts. In fact, we've only come across one so far, and we're excited about it, but it's new. But it's very exciting to think about the interplay between the care managers and the professional trust companies, or to have all of those services in one place, so that that the ball isn't going to get dropped somewhere, that the medical side, the care side, and the money side are going to be in place beyond where beyond you. And even if you're even if your son or daughter is taking care of your child with the disabilities, if your son or daughter is the same age as your child with a disability, at some point they're both going to be 75. And will your 75-year-old typical child be able to take care of your 75-year-old child with a disability? Maybe. Are they going to be able to do it effectively? Are they going to be able to have all of the tax issues and accounting issues and guardianship reporting documents in place, along with I feel like it's a full-time job, which is why we as parents do it, though. That's what we do, which is why we go back to the succession planning, and that it is sort of a mini empire, and you have to make sure that each role is provided for.
And the succession planning is not just having people to fulfill the role. Part of the succession planning is identifying, like Julie said, the life expectancy of the special needs child, right? And then how much will that cost? And it's kind of staggering, but the good news is that technology is our friend in these analyses, right? So you can really model out how much the care will cost. And now with having all of these managers out there that provide the different levels of care, you can really build a model that says, okay, if my child is requires this type of care, so many days a month, a year, and you can put a dollar sign on it, you can back into how you're going to provide for that. How much life insurance do you need? How much of the assets are currently invested? How much rate of return do you need? How much is going to be covered by government programs? So again, it takes a village, right? Using all these different people with their specialties, but it will give you a much better chance of achieving your objective of providing the desired level of care for that special needs child, rather than just winging it, just buying a life insurance policy and hoping for the best. No, now there's specialties out there, or I should say specialists out there with the appropriate technology that can really drill down to how much you need and how you're gonna achieve that.
And one other thing that's you might want to think about is, as your child gets older, are they going to be living with you, or would it be a good idea to have them move to either a group home, and not just any random group home, but obviously you're going to check it out, or but there's also facilities, and maybe facilities isn't the right word, but I remember when my son was born, I kept seeing this place, and I always wanted to go there, but it's in Cooperstown, and it's a campus, and adults live there, and they dorm there. You can see your parents, you can go home for a week, you can, you go home on the weekends, whatever you want to do, but you live there, you have a job, you can take classes, and you have a job out in the community, not just in this campus like setting. But it seemed like a nice environment. As parents are aging, you are transitioning your child while you're still there to living independently from you. So it's not something fun to think about, but it's an eventuality. So I always think if I can help my son through something, it's better than him just going it on his own because I didn't plan for it. So, Ray, are there any, or Chris, did you want to say anything else?
Yeah, I think we started off with if you fail to plan, you plan to fail, and it's emotional and it's very difficult to think through it. But once you start it, I think there's a sense of relief that whatever plan you put in place is better than not putting a plan in place at all.
And I think that, and I this is not meant to be doom and gloom or anything, just giving examples of the things that you need to plan for, and making sure that you're aware of the gaps that can be in place even if you have the best laid plans.
Which makes a lot of sense. Yeah, that was a lot of really good information. So there were a lot of questions, but really they all revolved around guardianship. I guess this is probably the really critical piece about who's going to be supervising. And there were a couple of questions where you mentioned government programs that could be available. So we'll get to the guardianship questions in a second, but do you help families identify which government programs would be appropriate, or who actually handles that?
So I can refer people to, there's New Jersey Perform Care, there's the Division of Developmental Disabilities. You can reach out to usually your county health department is where you're going to start, and you're going to make the applications to those service providers. And then you'll get, and I don't want to say this, but I don't want to say it this way, but I can't think of another way to say it, but you sort of get in the system, and then you get your benefits and you have a case manager, and they'll help you they'll help you make the applications to the other providers that you may be entitled to receive services from.
Okay, that's great. Okay, very good. So specific to guardianship, these two issues came up across about half a dozen questions. One is the process of obtaining guardianship through the courts and also determining competency. Could you just kind of describe how that works?
Sure. So we do a lot of guardianships. We do adult guardianships plus DDD guardianships or Title 30 guardianships. So we have many different situations, whether it's an aging parent or it's a child with disabilities who's about to turn 18. Typically with a child with disabilities who's about to turn 18, and this is across the board with all guardianships, you need to, the first question is, do they have capacity? And you need to get 2 doctor's reports, or with respect to a Title 30 guardianship for a child with disabilities, 1 doctor to talk about whether or not they have capacity, and you can use the IEP if they're still in school. So if you didn't get it from ages 18 to 25, you're sort of having to go back to get that second doctor. And if you have a relationship with 2 different doctors where it was the pediatrician or the longtime doctor and another neurologist or someone, that's fine. But sometimes the cost of getting a doctor's report could be $500 per doctor. With respect to the guardianship, typically it's a flat fee for making the application to the court. A court-appointed attorney is appointed for the incapacitated person, or the alleged incapacitated person. We call them the AIP. You go before the judge. the judge gets a report from the court-appointed attorney, either agreeing with or disagreeing with the reports and making recommendations. And then if there's no objections and everybody's on the same page, typically it's done on the papers. If the person or the incapacitated person or the alleged incapacitated person has an objection, perhaps there'll be a court hearing about whether or not the guardianship should be limited in some way or in many ways, or whether or not it should be permanent or temporary. I've had cases where the person needed guidance, but it was a temporary guardianship meant only for 6 months to give them the support they needed to become more independent. Then there's other guardianships where it's evident that the person is not going to be able to take care of their finances or their activities of daily living. Typically, it's a 2 to 3 month process.
Sounds like a lot. Sounds like quite the process.
It's not, it's like everything else. It's getting started. There's a lot of information to do in the beginning to put the complaint together, and then it's a lot of hurry up and wait. And then there's a flurry of activity when you're talking to the court-appointed attorney and waiting for that report, and then hurry up and wait for your court date, and then you get the letters of guardianship. Right,
that makes sense. And I know from experience with some of my own clients that have tried doing it themselves, they all wind up going to retain counsel in order to help them through this process, because it is incredibly complex and not just something that you can gather the documents, submit them, and then everything gets the ball rolling. That's just not the way it works.
It's hard, and I think it's especially hard if there's an alleged incapacitated person who does have some level of capacity in some areas, or who should retain some rights in some areas, because you're taking all the rights away from that person.
Right. So to that point, there was an interesting question about what if the guardian that's appointed fails to perform their duties, and there are no parents, family members, etc., around the individual who is the target of guardianship. What happens? Like, who figures this out?
So I think that's where you'll get into another system. So they'll either get in trouble with the law, or they'll be in the court system some way. If they're sort of sitting at home by themselves, there's going to be an issue with the neighbors, and they're going to call and probably send somebody for a welfare check. And if the police come in and see a situation where the person's unable to care for themselves, unable to, if there's hoarding, if there's infestations, or depending on what's going on, or if they're just not even eating, if they're not able to make food for themselves or prepare their own meals, there's going to be, they're going to be brought in, evaluated. They'll call, the social worker and see maybe a group home is the best place for this person, or what supports are in place. One, and also who is in charge, who is supposed to be in charge. There should be contact with the DDD, and that caseworker should be, because I feel like if the guardian is a little savvy and not doing their job, they might be fine taking phone calls and saying everything's fine. But at some point, something's going to happen, and somebody's going to become aware, and then they'll be brought back. There's in the statute, someone from the Division of Developmental Disabilities can either, one, move for guardianship, or two, step in and try to have somebody else appointed.
Okay. And just so everybody knows, because there are some people on Facebook that are in different states. So DDD is the New Jersey, the government level organization, the Division of Developmental Disabilities. It's OPWDD in New York. And so there's always some organization like that in your state, and you really must make yourself familiar with that. Okay.
And just one more thing. I practice in New Jersey, so this is not, the laws may be different in your state. This is not legal advice on what to do in your state, just an overview of generally estate planning tools and gaps to look out for. But
Excellent.
you want to check with the laws in your state.
Right. Okay. So anyone who has questions for Julie or Chris, can you please state your contact information?
Oh.
Sure. Christopher.Kelly. I'm with Equitable Advisors. So my email address is Christopher.Kelly, which is spelled Kelly at equitable.com. Christopher.Kelly at equitable.com. My phone number is 732-292-3357. Cell phone is 732-768-6543.
Fantastic. And Julie, I see you have it up on the screen. So your phone number is 732-483-6300. And Julie's email is jkennedy at berciklaw.com. So thank you both very, very much for all of this information tonight. And I really appreciate you doing this because it's valuable information, because I know just for me, the children that I started with 30 years ago are now in their mid-30s, right? I started out in a classroom of 5-year-old children. And so it would be interesting to know if all of this is set up for them or not. So anyway, it just got me thinking a lot about the kids that I'm working with and their families and I have worked with, et cetera. Anyway, thank you again very, very much. This was excellent info. And if anybody has any questions, please feel free to reach out to our two presenters. Thank you again for joining us. Bye-bye.
Thank you, Ray.
Thank you, Thank you, Ray. Thank you, Julie.
Thank you all for coming. Thanks, Chris.
Good night.
Good night.